And what is going on, everybody? This is Vinny Miletti with Miletti Law, the strongest name in law. The day now is August 2nd, 2022. It is a Tuesday. It is about 10 a.m. It is a beautiful day here in Brooklyn, New York. The weather is stunningly beautiful outside. I am sitting here in the office for whatever reason, not sure why. Anywho, I like to have these videos. Wait, before I get started, as always, make sure you subscribe to this channel. We seem to be growing. We had 5,000. We seem to be fluctuating. I'm not really sure what's going on here. Maybe some people are unsubscribing. I don't really know what's happening. But point is, we're about 5,000 people in. Let's keep this momentum growing. The more I see here, the more content I want to produce. The more content I want to produce, obviously, you guys and gals will learn a lot more. Obviously all this free advice and everything. So, certainly be more active, participate, jump inside. Make sure you subscribe to the channel. Also, maybe make sure you subscribe to the newsletter. Go to the website at www.milettilaw.com. It's MILETTILAW. MilettiLaw.com, MILETTILAW.com, and sign up for the newsletter. It's a pop-up window. You just go there, punch in your email address, boom, you're good. All right, so let's get down to it. So, I'm really not a criminal attorney. I try not to get into criminal matters, but it just, if you live in Brooklyn, you will undoubtedly have a criminal case at some point in your life as an attorney. It is what it is. Brooklyn is home to some very unusually motivated business people, and things happen all the time here. Sometimes people don't get along, people don't see eye to eye, things happen, such as fights, whatnot. So, anywho, I would like to I want to make a clarification here, because what happens, everybody's a victim, right? Everybody, the fight always started somewhere else. The fight was always your fault. The fight was always this fault. The fight was always that fault. Nobody, obviously, everybody, when you are outside of a court of law, everybody's aggressive. Everybody's ready to throw down and fight and defend themselves. When you're inside of a court of law, it becomes a very different game plan. So I'm deciding, I want this video to basically just kind of like walk you through how a court will look at it. Now remember, this is civil, not criminal. Criminal, my understanding, is beyond all reasonable doubt. There is an Article 35 defense and justification, which has to do with self-defense in matters of, assault, apprehension, whatever the case is. I'm not a criminal attorney. Of course, if you pay me, I will become one. But I try not to do criminal work. It's very difficult. It's very sad and depressing. And, if there's someone that genuinely needs to be defended, we'd love to defend you. But, I try to stay away from that. There are much better criminal attorneys than me. So anywho, but civilly, I'm on point. So when it comes to self-defense, you do have a defense in terms of a civil lawsuit for self-defense. Generally speaking, if you are attacked and you strike back, whatever the case is, or if you have fear of apprehension, you strike back, you could assert justification, which is self-defense. And that certainly is the case in a civil matter as well as a criminal matter. In a civil matter, it's a little bit different. Remember, it's 51%. It's not 99% reasonable doubt. Essentially, just so you're aware, the way it works out, in order to establish self-defense, the person who is in fear or apprehension has to reasonably believe that they're in such fear of apprehension, and that justifiable force must be used to stop the fear and apprehension. So just keep that. But the way it's looked at in buckets, right? So let's put it this. So we're going to pull out our trusty ruler here to start pointing. So let's put it like this. Bro arrives. Bro wants to start trouble. You, whatever the case is, bro gets in your face. You defend yourself, you push back, you knock out the trouble, crisis averted, you were in fear and apprehension, that's self-defense. Bro comes in, bro gets in your face, it stops, escalates again later on. So point is, each individual moment in which the escalation occurs, the initial aggression occurs, the escalation, the self-defense. Initial aggression, the justification, the initial occurrence, the initial aggression, the apprehension and fear, the act of self-defense. It stops. Initial aggression, the act of fear, the feeling of fear and apprehension, the act of self-defense, it stops. So each individual incident along the timeline is reviewed kind of like autonomously from each other. You could certainly make the case for the entire timeline. That's absolutely fine. That's something you can do. You could say that it's a continuing event. It's clear. It's always relative within the situation. It's always in the context, right? So there are hard and fast rules and laws. Simply put, again, it looks to whether or not the person is the initial aggressor. It looks to see if there was a reasonable belief of fear and apprehension, and then it looks to see if the amount of force used in return was relative to the amount of fear and apprehension. So it's always going to be a case-by-case basis. It's never going to be anything otherwise. In a civil case, it's going to be just 51% versus the 99% in a criminal matter. So, but the big takeaway from this video is that I want you to understand, while you can argue that it's this large continuing event and the fear never really stops, right? You could argue that. But for the most part, they're going to look at each individual aspect. So each individual event over a timeline of events, even if it occurs on the same day, even if it occurs at the same moment. So I just want to make sure that's clear to everybody. It's very difficult, and I understand, I understand we see criminal cases that are sensationalized in the media. For instance, the kid that, whatever, he went to that riot with his assault rifle, whatever the case is. And I do know we see cases that are sensationalized in the media. That is not the consistent norm. That is not the consistent practice. The consistent practice is it's a case-by-case basis. And it could really be any level. It doesn't have to be sensationalized in the media. It doesn't have to involve a gun. It just has to be, there is the initial aggressor, the initial aggressive act. There is a fear and apprehension. There is the actual self-defense, and then there's the calming of the situation. That's the paradigm in which it gets looked and reviewed, and that is in a civil case, not criminal. I mean, it's very similar in criminal, but criminal you need 99%. So it gets a little bit more. It's a little bit more difficult to prove in that instance. So here we are. That's the point of this video. The point of this video is that self-defense is a justification, even in a civil matter. I just want to explain the process, how it works, how you should be looking at it. Should you want to assert self-defense as a justification, how you should be looking at it. You shouldn't think that just because somebody came in an hour ago, you still have the same, kind of mental state. You still have the same situation an hour later. Could change numerous times. It could escalate and de-escalate numerous times during the time frame. So just keep that in mind. If there, obviously, if you have any questions, concerns, certainly let us know below. Let us know in the comments. Email us. If you'd like us to help you with any of your cases, more than happy to take a referral. But yeah, hopefully this was a little bit educational, kind of puts your mind in perspective how you need to be looking at these things. If you have any questions, certainly, you know where we are. As always, yours in law, love, and lifts. Staying usually motivated, everybody. Miletti Law, and we are out of here. And you have a great day.